Okay, this is in 9 weeks, perhaps 2 or 3 weeks ahead for rest of our topic, and it is my pleasure to see your class attendance reporting. Yes, actually I regularly received your notice individually, and I previously made several emails to be sent to your email account. So what good interaction I expect, okay, actually we see some progress in this law school department. We have this morning the speech competition. 6 students competed for 3 tickets to Chinese University for the finals. Actually, good opportunity to make a dream to travel China, and 철강공산대학 can meet your Chinese friends and would exercise your skills and English capability to speak and present your thesis. And the topic was very interesting, exciting. The presentation is generally excellent. We professors agree on the point. I'm pretty good about grammar or a manner and pronunciation, and even legal merits. According to Professor Bohenia, the legal merits is very high. You see, the Lynchianism. So some students would be highly oriented and was motivated to do the best. So we were happy, the professors, and this brief lunch. 3 students were selected actually, and the topic is very thought-provoking and actually dealt with many updated issues. For example, technology and self-defense in the highlight of criminal justice system, and their illustration is also exciting to cover the recent news stories, and a great time to be present, and we exchanged many ideas and thoughts to improve the skills, language skills of this law department of law. Good. Okay, thank you for your interest. And in this class, we'll take an opportunity to investigate the kind of free online legal sources. Now in the digital age, we have ample chances to surf the internet space. Actually, many public websites are devoted to provide information in their interest, and perhaps in some cases to promote the goals of organization, or in other cases could be a subsidiary to complement their main job. For example, professors or lawyers would manage the kind of law information website, and the website would provide fairly implicating scope of legal information. So in some cases, the public website could satisfy your expectations. If you are a legal researcher in some point. So it could be cost effective in one sense. However, the pitfall would not be be present in some cases. How do you consider the utility and any disadvantages to be prevented from being tainted? So about your research. So the information might not be updated regularly. The contrast could be found in commercial providers, and Nexus Last and Westro would be highly sensitive with competitive edge of updating cases like this, legal and once we have tried same-sex marriage in terms of this class purpose, and perhaps the Supreme Court cases about that were rendered in years ago, 2 years ago or not, and the docket number would have been assigned to denote the case. Nonetheless, the official citation in published form would still not be decided. So the kind of information would lack the exact citation. Even in that status of case, the commercial reporters would write the case and report it to the notice of availability of the client. So it's paid basis, so fee based, and some of subscription fee is required. One reason for is lacking could be so. That implies the commercial businesses in the operation of this service is highly consequential in reporting the updated cases. They would be fairly responsive to the change of laws, and of course they would manage the kind of technical team to maintain their business product. LexisNexis would be presented in fine scenery and also organized in any coherent structure and prepared to serve most effective legal research. So the commercial basis of information providers would be a major source to be referred by the lawyers of the United States and even in Korea, and but actually very stretching through the global jurisdictions, and many public organizations or government will entertain the kind of information required to pursue their responsibility. So what fairly in coverage about use and sharing, and they are the basis to train the lawyers or concerned policy administrators regularly, and might well be accustomed to the kind of a service provision. So basically, we consider the free online legal sources would not be so fine in comparison with commercial providers. Would often be inferior to the kind of context. However, that depends on the circumstances and situation. under which the researcher would like to practice their research operation. So we could not disregard kind of a new transformation we now see in reality in your personal computer analysis. So I expect some learning outcome through this class. By the end of the work, you should be able to evaluate online legal sources for researching policy areas. And also, I like to suggest to inquire yourself about this question. What are some potential benefits and pitfalls of free online legal resources? That is the kind of inquiry to be kept through this class. So assess the strengths and weaknesses of a particular website. Later, I would illustrate two examples from University of Basel and also the website of International Commerce Law provided by Pace University Law School. You will be called upon to provide some research report about the strategy, whether we would assign the CIST or not. You know the norms of CIST. It is most important international private law, I consider, and has been concerned of international sale of goods law, so sales law, international sales law, and also the member states is very in span, and the kind of impact is so consequential that often the national and international lawyers would have to consult the laws, international covenant, and as one international private law, and most brilliant success has been found in this case. Please consider the Hague Convention, one other peer subject, but have a limited scope of member states that will now be operating to cover several of European states, and often be viewed to share the many favor on the developed states. So the balance between the right of sellers and the buyer have been prejudiced to favor the developed states. So seller is in the status to entertain high degree of protection. So what is the point is that they could not track many other global states, and often be opposed by developing countries. That is what altered in the initiative of UNSTRA, and the product of CISG now will be considered a most successful uniform law movement. Well, and actually the jurisdiction and applicability of this case is focused on sales law. And Korea is one of country where we see most extent of interconnectedness. So interdependency in terms of international economy is very meaningful to vibrate our national economy. So we generally depend on imports and exports more than any other country. So it is one great pillar to sustain our national economy. So the strategy is very implicating and be approached in many ways of assessment. So evaluation is critical, and one of important agenda now pending to be decided. What ultimate decision generally in favor of a subscription. So we have to subscribe to CISG. In reality, we see its entrance in 2005. Nonetheless, assuming that you are a lawyer to provide advice about the prospect and strategic points to decide whether or not we enter the CIC province of law. So do we sign the treaty and become a member state? That will be inextricable if we consider China and Japan are member states. I'm not sure if Japan are member states. In any case, China is now one of our most close companions to keep pace on economic progress, and G2 now is talk about in global economic terms, and the kind of vision is highly foretold by many concerned economists, and the decision would affect the businesses industries of the Republic of Korea. So the Treaty Bureau or Foreign Ministry in ROK has launched some preliminary investigation project. So they commanded to organize some working group, which consists with four legal protection practitioners and 2 law professors, 1 judges, and 2 commercial diplomats, as well as team leader, who is a chairperson of that working group, and some bureau director of international treaty. So kind of working group is the most popular form as a matter of international organizations. Often the international agenda has been approached by organizing the working group. So many concerned intellectuals or practitioners would be called to participate. For example, you have learned the working group in the panel procedure, now based on the dispute resolution, dispute settlement resolution, and the kind of agreement to actually articulate some very in intricacies. So that is the trend to be transformed from the 1947 GATT. So actually one important change could be found in the dispute settlement mechanism in WTO, and the panel process, and we see a appellate body which is responsible to maintain the system of precedence. So they would interpret the conventions, treaties, now often be classed as WTO laws in its entirety. So they have interpretive authority, and the procedure would be progressed basically based on the working group context. So panel would be called upon to be responsive with the disputes and claims. Terms of reference would show the ultimate consequence and destination to be reached by panel and appellate body, and appellate body is exclusive in power and authority to in province. If you see the legal province is the responsibility. So the appeal only could be accepted when the allegation claims will point to the erroneous ruling about provisions or laws. What is the meaning of this provision, and how do you apply this provision to this fact? So the fact finding would not be the usual business. So the kind of process would fairly curtail when you stage up into the appeal proceeding. So working group, and also you will find another context. For example, Human Rights Convention of the United Nations. So the working group would be charged with kind of important work to investigate the facts, and in some cases may negotiate the interest countries or other parties, and also would prepare the kind of final recommendations for improvement human rights conditions in cases and others. So it is the kind of a practice actually, and in this